Concur.
Item 3C, Ms. Tanner.
Thank you. Docket number 1507-021 is the emergency petition of the Alliance for Solar Choice for declaratory order that Senate Bill 374 requires that continuous and uninterrupted net energy metering be offered to customer generators in Nevada. If you'll indulge me, I know we've been here for a while, but I'll probably give a little bit more than I normally would under the circumstances. On July 8th, the Alliance for Solar Choice Task filed a petition and seeking clarification that Senate Bill 374 of the 78th session of the Nevada Legislature requires that Nevada utilities continue to offer net energy metering to qualified customer generators pursuant to NRS 704775 as it exists in the existing NEM tariff, which we have referred to as NEM1, until the time that the Commission can approve the new NEM tariff, which we refer to as NEM2, and TASC requested that the Commission issue a decision on this by July 29th of 2015. Just in summarizing my recommendation, I would first note in large part, this proceeding is a matter of procedure and how to go forth with that procedure from here. While I acknowledge and I personally have great empathy for the emergency facing the solar industry, unfortunately, TASC co-sponsored the amendment to SB 374 that eventually became law, and that statute specifically precludes the relief that they seek today. It does not preclude the Commission from determining the appropriate terms of a tariff, interim or otherwise, and taking into account all party positions. Whether the bill in its ultimate enrolled form was what was intended by TASC or anyone else, it is unfortunately no longer relevant now that the legislature has rejected the issue of raising the cap. That is now law, and the Commission is bound by that law. Just as an aside of sitting here for 6 hours of public comment, I do hope that perhaps the solar companies can do a better job perhaps of educating its employees about what the Commission had the authority to do here today. Cannot touch the cap in my recommendation based on the clear reading of the law. The cap is what it is. It is what happens once the cap is met to the point of when the Commission issues the NEM2 tariff. It might be a matter of semantics, but that was something that we heard repeatedly today was please eliminate the cap, extend the cap, etc. The cap is set in statute. What is at issue is what happens when the cap is met between the time the NEM2 tariff is issued. So it's my recommendation based on my memo, which I know you've all read, is the following: that the Commission deny the petitioner's request with an expedited order, that the Commission construe the petition as a petition for interim review, and that the Commission consolidate this docket with dockets 1507-041 and or 1507-042, and that the Commission set this matter for further proceedings to determine whether an interim tariff should be approved prior to the approval of the NEM2 tariff, and if so, under what terms and the timing of that tariff. And I'm happy to answer any questions if you have any.
Any questions?
Chairman, I don't have a question. I just thank you, Ms. Tanner, for going through that. It was hard to listen to folks today thinking that we could have an effect on something that's set by the legislature. And our job is to basically pick up the pieces where the legislature left off. And I think the only reasonable solution was what General Counsel has provided for us. And I would note that Commissioner Noble has already set a very accelerated schedule, and I don't want to steal your thunder if you're going to say this, but to move into examining whether an interim tariff is appropriate or not. We take this very seriously. We have a very tough job balancing the interests of utility ratepayers as well as the public policy set by the legislature. So we hear what's being said. It's frustrating when we can't do anything about it necessarily, but we hear you. We definitely hear you, and I trust that this commission will find a way to make this work out. And through SB 374 inside out and backwards, trying to find some practical or novel way around this, as the bill anticipated every other outcome but for reaching the cap sooner. So I support that, and thank you, General Counsel's office, for, I know there's a lot of work and there's a lot of emotion behind this. This gives us a path forward, and I'm confident that Commissioner Noble will take it and as quickly as possible so we can get relief if appropriate. That was my only comment. Thank you.
Walking in here today, I was planning on supporting the recommendation. However, after nearly 6 hours of public comment, I'm concerned about the confusion about the cap and what we can and can't do. By setting this for further proceedings, it may give some people the false impression that we can affect the cap. We can affect the cap, but like you said, it's semantics. What the commission could do on an interim is approve an interim tariff that it looks exactly like it does today. It could approve something that looks like what NV Energy is proposing. It could look like something else, or it could look like nothing at all, and we do nothing until a final order is approved. Looking at it from a process standpoint, I was trying to figure out if this docket 1507.021 is consolidated into the two 1507.041 and 1507.042, how do I deal with interventions in 1507.021, which we haven't had at this point? I think it would be cleaner to deny 1507.021, but everybody that's listening to this obviously knows that the net metering tariffs are have been filed. For anybody who hasn't been following this and is clueless, the comments PLTI date is on Monday, August 17th, and there's a pre-hearing conference scheduled for Wednesday, August 19th, and the hearing for all the parties that are granted intervener status or are automatically in, which are staff, BCP, and the applicant, is on Friday, August 21st. And I plan on, depending on what evidence is presented, I will bring forward a draft order, and my goal is to have it on the August 26th agenda. So those are my reasons why I'd like to simply deny this petition and direct everybody to the two net metering tariff dockets that have been filed by NV Energy. I just think it will be cleaner and reduce the confusion.
I actually agree with you, Commissioner Noble. There is clear belief that we can affect the cap, when it's very clear by law that we cannot. And it appears to me the task's petition was primarily, the petition for relief was to affect the cap. So if they're asking us for relief that we're statutorily incapable of providing them by setting it for further proceedings, I think we're injecting some confusion into the process.
And I hadn't thought about the procedural component of setting this for further proceedings, because that may even delay it further. And that, my primary concern, and I really admire the fact that you have a lot of ground to cover between now and our next agenda meeting, and thank you for taking that on. With your representation and thinking through the procedural component of that, let's keep this clean and let's focus on getting the facts that we need to have something in place. I don't think anybody here is intending to kill the solar industry. I certainly, if anybody questions my professional career, they would know that that's adamantly not my position, but I need to weigh in on the facts as they come in through this case. So I like your plan, Commissioner Noble, and I think that that's a good way forward for us, and clean and quick.
Okay. So why don't we, I move to deny the petition and issue the order.
Second.
Concur.
Items 4A, 5A, 5B, 5C, 5D, and 6A brought to us by Declatory Operations Staff and County Board Office after the comment. Unless any commissioner wants to bring item now for further consideration.
No way.
I'm done.
I move then the commission accept the recommendations contained in staff's briefs and notes regarding items 4A, 5A, 5B, 5C, 5D, and 6A, and issue the appropriate orders.
Second.
Concur.
We now let's move to public comment in 7A. Is there anyone in Carson City?
Yes, Chairman, Fred Volz.
Again, for the record, Fred Bolts. Unlike EP Minerals' request for new natural gas service from Southwest Gas in item 6A that you just approved, Southwest Gas has failed to answer key questions about the extension of gas service in docket 15-5025 to Apex, Mesquite, and Spring Creek. This docket is presently in the workshop phase of consideration and not subject to evidentiary submissions only from named parties. Unanswered questions were asked by interested parties and still have no response. Information submissions required by applicable NAC provisions are also absent. It raises the process question of why all pertinent questions and information submissions are not required to be completed by the presiding hearing officer. The applicant has failed to provide information required by NAC 703.175, Section 6. The applicant has not fulfilled NAC 703.175, Section 8. NAC 703.205 has also been ignored by the applicant. Until submitted questions are answered and NAC information requirements fulfilled, it would be imprudent for the PUC's policy analyst or hearing officer to develop and issue any recommendations to the PUC. A similar problem of unanswered questions posed by interested parties exists involving the same hearing officer and policy analyst for docket 14-10,019. In this docket, NBE requests implementation of a new prepayment program for utility services that radically alters customer protections contained in the dated Consumer Bill of Rights and requires significant subsidies from the vast majority of ratepayers who won't participate in or benefit from the program, as well as hefty new transaction fees and service charges for those least able to afford them. These two dockets beg the question, how will procedures change in the PUC and quasi-judicial construct to ensure all pertinent questions posed by interested parties receive timely, accurate answers from petitioners seeking the PUC's approval? Additionally, these two dockets highlight a pernicious practice. Utility applicants have a disincentive to prudently add costs to their reimbursement requests because they receive a guaranteed 9.75% return on PUC-approved costs embedded in rates charged. In an environment of slow demand growth, utilities want to grow their profits and can do so by suggesting investments that make no economic sense. Thank you.
Is there anyone else for Carson City? I have no other cards, Chairman.
Okay, I have one from Ms. Judy Bundler.
Good afternoon. I am an intervener on Searchlight Wind. I would respectfully request that you read the comments that I turned in this morning, whereas the original proposed agreement that was recommended by your staff is the appropriate one. The motion that was filed by Searchlight Wind stating that no prudent developer would go forward without all of the, with the litigation pending is patently false. We have provided proof of at least 4, we could have got 50 projects that have gone forward in spite of litigation. They have allowed their Clark County use permit to expire, and the reason expired is they neglected to tell Clark County Planning that the ownership had changed. This is not Duke Energy. This is, quote, Apex Clean Energy from somewhere in Virginia. There a speculative firm. They are currently fielding lawsuits directly in at least 4 states over their wind projects. There is no power purchase agreement, environmental issues. Solar and renewable energy does belong on the roof. We don't need 30 miles of new road through the pristine desert around Searchlight for a company that may or may not even be able to finish the project. The production tax credit for wind is expired. Even Warren Buffett says the only reason to invest is wind is because of the production tax credit. Just yesterday, I learned that in federal court in Northern California, wind energy companies' request for a 30-year Eagle take permit was set aside. Spring Valley Wind, the only operating industrial wind farm in Nevada, has a capacity factor, supposedly, 157 megawatts. They've been delivering 21% of that number. California wind farms, the first quarter of 2015, delivered 13% of their nameplate capacity. Already at the Ely wind farm, there have been 2 eagles reported killed, golden eagles, untold numbers of bats and other birds. And I understand the price that NV Energy is paying for the wind power that does come out of Spring Valley is somewhere between 15 and 20 cents per kilowatt hour, and that's their wholesale price. So I ask you read the facts that are in my comments. Thank you.
Anyone else want to say this?
For the record, Angel, as somebody better catch your general counsel because she's going to pass out. I want to thank her for actually doing the memo. Fred and I reviewed it last night, and we thank her for her thoroughness on it. Now, for some comic relief, for the last 5 hours, I've been targeted as a shill for NV Energy. Apparently, nobody knows who I am. Now, I have read through NV Energy's flex pay latest filing. I'm starting to get tired of their hide-the-reality bastardized version of hide the salami. Even Stevie Wonder can see it solely for their benefit. The pink elephant is that they want to basically eliminate outstanding receivables under the guise of offering more options to their customers. With all their legal shrewdness, you would think one of them would come up with a standard confession of judgment for outstanding accounts when they want a payment plan. Have a couple of employees handle this, the recovery of AR will cover their salaries. With payment arrangements, they are required to fill out a template with bank and employment info that is in fact the COJ, first payment with the check. COJ broken, once a week an attorney files and records the judgment, has the writs prepared from templates, drops off at constable's office to execute. I did enough writs and they are so easy to file, even a Solar City sales rep can do it. Hire a couple of employees who know what the word skip trace means, and you can assist AR in finding them. By turning them over to collection agencies who can't do COJs, and most likely NVE isn't going to fork over costs of the suit, it basically goes nowhere. Remember, they have to follow the FDCPA and NV Energy pieces. Employees don't. Come on, PUC, this is a viable solution, achieves NV Energy's quote underlying purpose of flex pay. Or are you afraid that I can resolve this without all the smoke and mirrors? Commissioners, I want to thank you for denying the petition. It was the only fair, reasonable sensible and lawful thing to do. And I hope the next time the solar industry disperses the Kool-Aid, they would tell them how the Kool-Aid is made. Thank you.
Anyone else? We're adjourned.